Welcome back to the Kelowna Real Estate Podcast. I'm your mortgage broker host, Taylor Atkinson.
And I'm your real estate agent host, Matt Glenn. What's happening, Taylor?
Big news today, Matt. If people aren't getting enough of our faces, we are now on YouTube. So go check us out. Kelowna Real Estate
Finally,
Podcast.
we are on YouTube. We've joined that side of the earth. So can't wait for you guys to see us and hear us.
Yeah. No, today was an awesome show. It's a long one, but lots of good information in there. Dani Brito, local lawyer at Acorn Law. She's awesome. I know you've worked with her. I've worked with her with clients as well.
Yes.
Man, she is like so fast, so accessible, great knowledge. So
we could sit here and ask her questions all day long. She likes talking about it. We like talking about it. So
yeah,
this episode goes a little long.
I mean, she's just a good, balanced life, happy person, So if she's not part of your team,
never had any regrets.
Yeah. She had some great answers for our final wrap-up questions. So stay tuned. You'll like it.
This episode, like every episode, is sponsored by the best brokerage in the Okanagan, Century 21 Assurance Realty. It's where I am at. It's where I've always been at. I like it here. I think you will too. If you're an agent looking to make a change or someone looking to buy or sell a house, call the agents at Century 21 or just me. I'd appreciate the business too.
All right. Enjoy the show, guys. Welcome to the show, Dani Brito. Thanks for joining us.
Thanks for having me.
How we like to start our show is just you connecting with our listener. What's your perfect Friday look like? What makes you productive? What gives you energy? And then leading into the weekend, what do you do for fun?
Honestly, productivity is everything around here. So we are all working moms at our office. I shouldn't say all, most of us. So we are about the most efficient group you're going to find. So to me, my perfect day is I'm a morning person. I get up early. I would love to get a workout in, get everything organized, get the kids ready for the day. And then I'm into the office as early as possible. That's when I get all my best work done. And if I can be home to cook dinner, that's the dream. I'm one of the weirdos who actually loves cooking. If only my kids would eat what I made. But one day.
You get to cook like 3 things every night. Perfect.
Exactly, right?
Yeah.
It's a thing.
Yeah.
But yeah, what makes me successful? I love what I do. And to me, measure of success is being happy, coming into work happy and leaving work happy. Doesn't happen every day, but by the vast majority of it, I truly, truly love what I do. I love the people I work with, and I get to be a mom too, which is super special and a little bit rare to have as close to a work-life balance as possible in the legal profession. So yeah, I'm happy.
Yeah, that's awesome. I feel like as the transaction goes on, like the stress builds up and the time crunch is there, and you guys are kind of the last in line. So if you got a good balance, you're doing something right.
Exactly right. And that's our main goal. From my perspective, my goal is that no one knows how hard we work. That from the outside, you come in, my desk is totally clean. It's like, what does she do all day? I'm grinding it out, but you would never know. Yeah. My 5-year-old, he says, what does mom do for work? She does emails. And I'm like, that's 99% of the way there. Is I'm corresponding with clients. I'm corresponding with mortgage brokers, realtors, whoever I need to get everyone on the same page. So that's kind of our role.
Yeah, you are lightning speed. I love it.
I'm never far from my computer. That's for sure.
Yeah. Where are you guys located? Your office? You were just talking about it off air.
Yeah, we're just in the Lower Mission area of Kelowna. So we're just on the corner of Richter and Lanfranco. Very deliberate in that we have free parking outside of our building. We're in one of the Mission medical buildings. So it seems like every person's family doctor or specialist is in this building. So I'm like, oh yeah, I know where that is.
Yeah.
And strategically, we're located very close to the majority of the banks. We're to and from the banks all day, every day. So we have everything right around the corner. And it's beautiful. We're steps away from the beach. So no one can complain about that.
Yeah.
That is a good point about going to the banks, because you guys must have to make like multiple runs a day, eh?
We do, yeah, because when money is coming in or going out, depending on the lender, sometimes we have to go out today, for example, to go pick up a bank draft to close funds from a certain bank. And then when we're paying out funds, the part the clients really care about, we're tootling down to the bank to actually deposit the solicitor's check into their trust account. So the only time we run into issues is kind of those virtual banks or credit unions that don't exist here. So those are the ones where people run into a few more hiccups on it. But again, we ask in one of our initial contacts, where do you bank? How do you want to get the sale proceeds? My goal is there's never surprises. Surprises are good for birthdays and anniversaries, never from your lawyer. So we strive to avoid surprises.
Yeah, that's a good rule. So Dani, before we jump into the law questions, like I just have a question about the market. Like, so obviously you guys see from all the brokerages, all the agents, like, has it been slower for you this summer, or is it picking up, or like what's going on, like as a volume perspective from you?
Volume perspective, I would honestly say we're probably on par to where we normally are in the Okanagan. It's slower in the wintertime, busier in the summer. With interest rates where they are, the new announcements about striking out Airbnbs and similar short-term rentals, we didn't know what to expect. There's also a lot of condos and things like that that are finishing up. So pre-sales from a few years ago getting ready to close. So I thought it was going to be a lot more dynamic and interesting than it is. We just keep on keeping on. I've heard different things though from different firms. Again, we're a little unique in that we cap how many files we take. We're definitely not a McDonald's. So we try to provide the absolute best service that we can for every single deal that comes in the door. So we're pretty careful about that and protect the service that we provide. But I'd say it's pretty normal, to be honest, which is a bit shocking. I'd say this is the first year, I don't know if you guys have noticed driving around, summertime Kelowna traffic is here. Yeah. And it's the first time I've really noticed it since COVID that, you know, it was a little more chill in the summers and now driving home takes a bit longer. But in the real estate market, it seems to be about the same what we would expect in the summer.
Interesting. That's a good anecdote too about the traffic.
It's a time out there. Leave some extra time if you're coming or going or leaving town or even driving for groceries. But you know what? We can't complain. We're lucky enough to live here. Sitting out on the roads, it's not the end of the world.
Everywhere you drive to, like it takes half an hour, but it's like you're staring at some lake, you know, like it's pretty beautiful. Right? Yeah. You
get some good music going, you're good.
Yeah. Or actually a great podcast would be even better.
Yes.
Nice plug. Yeah.
Yeah, I got you.
Tell us just kind of start to finish what a perfect transaction looks like, if there is anyone in solicitor mindset like that has no surprises. What do you like to see start to finish?
Yeah. Oh, that's such a good question. So the earlier you can get a lawyer involved, the better. Now, lawyers, they'll quote in different ways, right? So some people will quote all in. That's what we do. I'll kind of elaborate more on that. Some will bill based on time. So it's literally starting a stopwatch and every, 0.1 is every 6 minutes you're adding to the clock. Some will do kind of a hybrid where they give all in and then there's some disbursements. So disbursements are out-of-pocket expenses for registration, searches, things like that. So it's tricky to know unless you specifically ask those questions. And if you're calling around for quotes, it's hard because you might very well be comparing apples to oranges and not even know. Why we do all-in pricing is so that people can reach out as early as possible, know that it's not going to change their price, and know that they can ask us questions. Because at the end of the day, that's really what we're here for, and that's where our value add is. There are lawyers and notaries all over the place. We need to be accessible and to actually answer and provide service. So the earlier you can contact a lawyer, the better. They should be reviewing the contract. So if it's a purchase transaction or a sale transaction, they should be reviewing the contract to purchase and sale. They should be reviewing the title search and actually providing advice on all of that. If it's a refinance or something like that, again, as early as they can see the commitment letter and start looking through, because you'd be amazed how many surprises there can be in any of those documents of steps that need to be taken, things that people just don't think about. So again, the earlier that you can get someone thinking about it, talking to them, and just asking basic questions is so nice. From there, really, the biggest things are making sure that the client is going to be available for signing. That's, again, one of the early questions that we're asking are, is there any restriction on your signing ability? Because some people work away, right? They'll be here for a week, they'll be gone for a week. They'll be here for a few days and then they're gone for a month. So the earlier we can hear about that, the better. And if people are planning vacations, this is a big one, Kelowna in the summertime, people are on vacation. What can you do? Yeah. But if we know about that ahead of time, or ideally, if people could avoid booking vacations right on the closing date or, the couple days prior, that's great. But again, as long as we know, generally things can go pretty smoothly. But I think just, again, making sure you're available, making sure you contact a lawyer as early as possible, and then also just making sure that you ask questions that you want to ask. Because if you don't ask them, those are the only dumb questions, right? I think fear sitting across the desk from a lawyer or on the other side of email as a lawyer and say, I don't know if I even want to ask this question. Is this going to make me sound dumb or like I don't know what I'm doing? You don't want me doing your root canal. You don't want me doing your taxes. I know law. That's it. Yeah. Right? So you have to ask those questions at the end of the day. I think that's what's really important. First-time homebuyers are usually, as funny as it sounds, usually the most comfortable asking questions because they know that you don't know or you haven't been through the process before. Yeah. It's typically the people who haven't bought or sold in a few years, right? They should know what they're doing. Processes change all the time. So you have to, again, be able to ask those questions.
Yeah, you make a good point. For some, home buyers are like the best at asking those questions, especially with lawyers. We were allowed to do virtual signings, during COVID. What changed? Like
Mhm.
in the fall, they've taken that away, most lenders in BC. Can you just walk us through why they went back? Like it seemed like such a convenience.
Well, they didn't ask me. So there's that. We found it so helpful. The scenario I was just talking about, people who work away, right? They're doing shift work up north or out of province or something like that. The biggest hurdle for us with the virtual signings was verifying ID. The list to get it verified properly in accordance with not only the land title office rules, but also the law society rules, they were so stringent and so tricky to me that honestly, very few people actually could. If I knew people were going away, they could pop in my office for 2 minutes. I physically check their ID. We're off to the races. I can sign with them virtually. It was amazing. It was so helpful. But as you mentioned, the Law Society and Land Title Office has basically said no to that. There are a few exceptions. If someone is signing outside of BC, we may still be able to get an exemption for it. And then similar, there's actually always been a process for if you're familiar with someone's signature. But again, it can't be someone you've never met. Like I need to know them. I need to know what their signature looks like and all that kind of stuff. So it's a lot trickier than it once was, but definitely not impossible. Say you're out of the country and you're not coming back for the next few months, or at least until after closing. We usually can inquire with the lender and say, hey, is this an option? It depends on the lender's policies. Or to be quite honest, it's usually cheaper and easier to send the person to a lawyer or notary local to them. But that doesn't help much if they're on site somewhere, right?
Yeah.
And it's an hour or 2 hour drive into the closest town. Like it's very tricky for that. So I wish it was still more prevalent. I loved it. But I think probably people weren't following the ID requirements as closely as the Law Society or Land Title Office would like. And someone has soured it for all of us, but that's okay. We're dinosaurs. We don't like changing. So to me, one of the major silver linings of COVID was the virtual signups. And things are changing oh so slowly. Last week, the Law Society has approved us witnessing statutory declaration, so sworn statement where you can almost picture hand on the Bible kind of thing. We're now allowed to do those virtually again. So it took a few years to circle back to it. So maybe, just maybe, we might get there again.
Okay, good. Yeah, that was a lifesaver. Like you said, like the camp workers are the biggest one, or someone that's moving from Ontario to Kelowna,
Yeah, exactly. And they typically know ahead of time, right? So if you ask the questions, we were able to get them into a lawyer, get them to come into our office, like I said, for a super quick flash me your ID and we're good to go.
Yeah. Something that comes up quite a bit is setting up the title in terms of ownership, percentage, if there's a co-signer, parents are helping, estate planning. Is there like any way to simplify that as much as possible so Matt and I can understand?
Yeah, totally. So whenever there's more than one owner, we have to have a discussion with the clients about how is this relationship going to be structured between the owners. So there's generally two ways to set it up. The first being joint tenancy. What that means is if it has to be equal between the owners. So if there's two owners, usually this is a husband-wife kind of situation, 50-50. And if one of them passes away, there's what's called a right of survivorship. All that means is if one passes, the surviving spouse or owner has 100% of the property. It's pretty much automatic. There's a quick filing with the Land Title Office. No questions asked. You're good to go. The alternative is tenants in common. So they make them sound virtually identical to make it extra confusing, but the result is so totally different. So even if you had two owners, they each have decided we're going to own 50% of the property. If one of them passes away, their 50% does not go to the survivor. It goes to their estate. So sometimes we can see that with blended families. Someone wants to make sure their percentage goes to their child, something like that. Or where we see parents going on title. We're seeing that more and more in the past few months. I'm not sure if you guys have noticed, but on the contract to purchase and sale, there used to always be 2 lines for buyers and 2 lines for sellers, kind of picturing a spousal situation. There's now 3. So it just goes to show how prevalent it is to have an extra signer going on and an extra owner. So with tenants in common, you can pick whatever percentage you want. So you can be a third, a third, a third. You could be 1% and 99% to the actual, owner of the property. Where it became more complicated this year, another plot twist that came into the story, is the need now to file declarations with respect to bare trusts. So we've had to declare them for a while, but it never really came up. Bare trust, what that is basically it's a relationship between two parties where one person is the beneficiary. They're the ones who are going to benefit from the property. Let's say if it's a rental property, the beneficiary is the one getting the rent money. And then the trustee or the nominee is the person who is going to carry out the wishes to make that actually happen. So sometimes we'll see a bare trust where one party owns the property on behalf of that ultimate beneficiary. We sometimes see it come up with people with disabilities who can't have assets in their name. Sometimes it can be for estate planning, it can be development. It comes up a lot. But where I don't think the government really thought about it is technically, if parents are going on title, so they're co-signing and they're going to be owners of this property, unless they're getting an actual benefit out of the property, it's now a bare trust. And they need to be filing not only the declaration, which costs a bit more at the time of closing and legal fees, but it also now requires an annual tax filing. A T3 has to be put in. So they've kind of waived it for this year because I think they said, oops, we didn't quite see the, catching that group of people. But in theory, it is still a thing. And so we have to be talking to clients about this on every single transaction. We have to ask the question and we have to make sure that they're advised. Now, lawyers and notaries are taking like a wide variety of approaches to this. Some are ignoring it entirely, which I don't think is appropriate. Some are saying parents are going on title. This is a bare trust every single time. Again, I don't think that's appropriate. You have to have the discussion, right? We've come across situations where the parents are going to park their RV on the property. Perfect. That justifies having 1% of the property. No bare trust, you're good to go. We had one where they wanted to do gardening. There was a little garden bed that they were going to build in the backyard, and the parents were going to go and plant whatever they wanted to plant in there. So again, like you just have to have the discussions and see what the situation is. So that's a really long-winded way of saying it totally depends on the circumstances. And I think people have to actually get the advice. And I mean, the easy peasy one is husband, wife are going on there. There's no other situations we need to be thinking about. And it's going to be a joint tenancy. 50-50. If one dies, it's all going to the survivor. Basically, anything outside of that, we have to be talking about it and figuring out, do they have an estate plan? Have they thought about this? And where multiple people are going on title, whether it's parents, a roommate, maybe a boyfriend, whatever, maybe it's time for a co-ownership agreement or something else setting out each party's rights and obligations, because the goal is that's a total waste of money and no one ever looks at it. But if something happens, meaning a couple separates, parents get divorced, someone passes away, what's going to happen to that property? And it's very nice to have a bit of a blueprint of setting out what that looks like.
Would you always recommend having an estate plan to, I guess it doesn't entirely avoid probate, does it? But like, is that step one for you guys to advise, okay, there should be obviously something put in place within an estate if there's multiple people involved?
I mention it at the end of every transaction. I hope it doesn't come off as sales pitchy to clients, but it's just kind of a generic, if you have an estate plan, this is a good time to review it to make sure it all still syncs up with your new acquisition or sale. And if you don't, let me know, or if you want to discuss it, I'm here. Where estate plans come into importance. So estate plan, what does that mean? A will. So a will takes effect from the date of death. You pass away, who is going to be managing your estate and where your assets going to go? So who's benefiting from this? That's typically the one that people are most familiar with. If you don't have a will, the government does actually set out what's going to happen to your estate. So who it's going to go to and what percentage or what dollar amounts or whatever, just depending on your family dynamics. The next of kin situation, it's a little more complicated than that, but that's kind of how you can see it. So as long as you're okay with that, you can go without a will. It makes it a little more complicated for your family because there's no one written in the document saying, I'm going to be the one stepping up and going to talk to the banks or dealing with the lawyers or accountants. So there's a few extra steps, but it's not the end of the world. Where I say that a will is 100% essential once you have kids, because that's also where you appoint guardianship for the kids. And then if you have any specific wishes for the property itself. So making sure if you wanted it to go be sold or held or whatever that's going to be, that would go in your will. The piece of your estate plan that I think is the most important, ignoring everything else that's going on in your life, if you own real estate, you should have a power of attorney in place. So what a power of attorney is it's a document that appoints someone who would be able to sign legal documents on your behalf. They can do some other things too, but keeping it to real estate. If you could picture this situation where my husband and I own real estate together, and we've lived a long, happy life, and now all of a sudden, oops, Dani has dementia and she needs to go into a care home. She can't, support herself. My husband's not going to be taking care of me to the extent I need. We need to sell the house so that I have money to pay for the level of care that I need. I no longer have the mental capacity to sign to sell the property on my own. And funny enough, this other spouse doesn't either, unless there's a formal document appointing them to be allowed to sell it. So power of attorney, you spend a couple $100 to set it up. The goal is it's good until the dawn of time. I've used some from the 80s, 90s, and they're as good today as they were back then to allow that to happen, right? So it truly is allowing you to access or use your money or assets, I guess, in a way that makes sure that you can actually live out your days. Kind of the way I view it is, again, ignoring if you have kids and making sure they're provided for. I'm gone. If my assets go to the wrong place, it's not going to affect me personally. If I need money and to sell a house so that I can fund care for myself, that's going to directly affect the end of my life and how I'm living out my days. And I really care about that.
Yeah. Can you retract the POA, power of attorney?
Yep.
Yeah. Okay.
Yep. You absolutely can. So as long as you have capacity, you can retract it. It's best to give notice to the other people who you've appointed under your existing power of attorney. Where that's most important is if they have an original, they kind of have a loaded gun that they could go out and transfer property or do whatever. So it's kind of the formal notice saying, hey, you no longer have these powers. But again, it's kind of one of those things you give notice, but you can revoke it at any time. You can change it, do a new one. Typically where we see people do power of attorneys is when they're doing the rest of their estate plan. And then typically once their children reach of age that they would feel appropriate appointing them. So typically people kind of do 2 power of attorneys over their lifetime. So again, for a couple $100, it's money so well spent in my eyes. The alternative is, so let's go back to my scenario. I need to go into care and no one else has been appointed to be able to sign to sell my property for me. There is a process through the court, but you're talking, it can be months in court, $5,000, $6,000, $7,000 in legal fees. You'd be kicking yourself if you didn't have that one document in place. That to me, again, if you're responsible enough to have a mortgage and buy real estate, you're responsible enough to get a power of attorney done so that it's tucked away. And if anything happens, you're good to go.
Yeah, they should almost make it mandatory, like as part of the process, eh?
Yeah. Well, in my eyes, yes. But there are also people who they're saving every single penny they can, right, to buy their first home. And I get that. But I think, again, as long as people get the advice that, hey, now that you have this, this beautiful asset, you need to think about kind of the worst case scenarios of what happens if you need to sell it and you can't. Or power of attorneys are great. You win the lottery and you're out on a fabulous vacation. Someone can go deposit your check for you. Like, perfect.
Yeah. Hey, if I'm on vacation and I win the lottery, I'm happy. Yeah.
Right? It's well worth it. So well worth it.
I love the optimism.
Yeah. So it's kind of one of those things. I think it's money so well spent to just have a plan in place so that you don't even have to think about it, worry about it. And your family doesn't have to think about it and worry about it. If there's a major accident and you need to sell your house to pay for care or major surgeries or something, right? Your family's going through a hard enough time. They don't need to be going through court to get the same power they could have had with you a quick signature on a document from a lawyer or notary.
Yeah.
Awesome. So, Dani, when you're reviewing a title for a purchase, like, should the lawyer be pulling all the charges, everything registered on title, or should the realtor, or like, how do you think that should work?
Doesn't matter who pulls them. It just depends who's putting out those expenses. Like I said, we do all in pricing. So when we're
pull them all?
We cover them. Yeah.
Okay, nice.
If there's a 10-page title and they're all statutory right-of-ways and it's on a condo and we know nothing's going to come of it, I'll ask and say, do you want me to pull these? Like it's going to get pretty expensive. It's roughly like $20 for each one.
Yeah.
And then we typically are also pulling the plans associated with right-of-ways, easements, things like that, because land title office doesn't make it quite so easy. Sometimes they do. And you'll scroll down to the bottom and there's the plan, just looking beautiful. If not, we have to pull that one too. So whether the realtor pulls it or we pull it, I still want to look at it. And the time to review the title is before you remove conditions. And I think a lot of people don't get a lawyer to do it. Again, maybe it's because they don't know. Maybe it's because they don't want the added expense. But to me, the major value from us is giving that advice early on. So the client has the opportunity that they can back out of the deal. And they have. Like, we're certainly not out there to kill deals. Like, that is the last thing we want to do. But if you say, I have young kids or I have a dog and I need to be able to fence in the backyard, that's the plan. And there's something registered on title that basically prevents you from doing that, the client needs to know. Yeah. Right. And so it's kind of one of those things where I think you'd be better off having a lawyer do it, even if you did have to pay extra for it. It'd be similar to getting a home inspection done. and the pros and cons of getting it done or not. Do you want to go in blind or do you not want to? But again, in my opinion, lawyers should be looking at it every single time. I think some lawyers, if we don't get it until after conditions come off, there are likely people who won't bother looking and pulling it and doing all the steps that you otherwise would be if you were giving advice that could actually be acted upon. Because once conditions are off, it's too late. You have the knowledge, you can't really do anything with it or, run for the hills. So that's important too, right? Is to still follow your processes, follow your steps. And I think that's good advice for lawyers, realtors, mortgage brokers, any professional, is to follow your steps, follow your processes. Don't get compliant or lazy about it, because the one time you don't do it is the one time that it's going to come bite you one day. Yeah. And I can comfortably say, if anyone ever asked me, did you pull this title? Did you review this title? I don't even have to remember the file. I can tell you with 100% certainty, I'm sure I did, because I always do.
Yeah.
Right. And so there is comfort in that.
Yeah.
So we're looking at everything. Like
Nice.
We're looking at who owns the property. We're looking at, do the names sync up? Right. If there's two people registered on title and one on the contract, has someone passed away? Like, what's going on here? Yep. We're looking at the legal notations. Usually those are for the benefit of the property, or kind of things that aren't really going to bother you, permit variances, anything like that. But we do want to see if there's bylaw infractions. Seeing anything like that's going to be on there. Another one that's often missed under legal notations is personal property registry notices. So those would be for, I don't know if you got financing for a furnace, and now it's been sitting on there and people keep forgetting about it or never circling back to it, like those sorts of things. On the charges, those are all things that are going to be encumbering or affecting your use and enjoyment of the property. You might not care about 90% of them, right? Yeah. It's never come up, whatever. But to go through them one by one and make sure that everything is still consistent with what you would expect, I think is just so important, because you need to know what you're buying.
Here's a situation I'm thinking. Like, say you don't like your house anymore, you want to move across the street, but you want to put a covenant on title saying that your current house can't go any higher than, say, 20 feet because it's going to mess up the view of the new house that you're buying. Can you put a covenant on title so that the future owner can't do anything with that property? Is that something?
And can you do this in McKinley? Matt's just asking for a friend.
I've had this situation come up in a few different ways, and that's just the example I was going with.
Yeah, so covenants are interesting, right? So what a covenant is, the usual ones we see, a developer goes and they need a city approval for various things, and the city saying you can do this or you can't do this, and it's going to be registered on title, so that it not only affects you, but every owner who is ever going to own this property down the road, unless it's discharged. So that's kind of what it is it says either you can do something or you can't, or you must or you won't, whatever. So who needs to consent to that? The registered owner of the property has to consent to it. So if you're still the registered owner of that, you're probably not going to run into an issue. If you've already sold the property and then you're saying, oh, hey, remember me? I actually want you to not build over X height. They're probably going to say no, because there's no real benefit for them, unless you're paying them a whack of cash. And sometimes people are cool with that. The city has to generally agree to it for most things.
If they're part of the covenant, you mean?
Yeah. If it's being amended, removed, anything like that. And then if there's a mortgage on the property, the lender actually also has to sign off on it to confirm that they're okay. Typically, they don't care unless it's going to be affecting the value of the property. If the value is going up, lender's happy. If the value is going to be going down, not so happy. They're not signing it. Yeah. So it can feel like a super easy, simple process, but the time that it takes to get everyone on board and signed off on everything, it can take some time. Getting them removed, really tricky. One that we do get questions about removing sometimes are statutory building schemes.
Yeah.
So what a statutory building scheme is they're registered typically when a neighborhood's being developed, and the developer wants all of the properties to be of similar look and feel, so that you don't have a mega mansion on one lot and a teeny tiny trailer on the next.
Yeah. And then a log cabin on the next.
Yeah, exactly right. So they register these statutory building schemes on there with the intention of keeping some consistency in the neighborhood. It can be what it looks like. It can be what the landscaping looks like. This is where sometimes you run into no fences or no RVs in the front yard, no clotheslines, things like that.
Cedar shingles.
Yeah, right? Like it can be anything, whatever they've agreed to, as long as they still own the whole development. Again, they're not looking for consent from individual owners. They just slap it on there and it affects everyone.
Yeah.
There's also restrictions on use. So it can say specifically no business in the home. So that was a typical one from way, way back when, 70s, 80s, 90s. In today's day and age, it's a little bit different, right? Like there are a lot more people working from home. Now, who's going to complain? Probably no one, but in theory, you could be offside of the statutory building scheme. What's important to note about statutory building schemes is the people who enforce it are the other owners of properties under that same scheme. So it's not like the city's coming to you and saying, it said no chickens in the backyard, which is a funny one. The old ones always say no chicken, no swines, da 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 da. So you can't have chickens, you can't have cow, whatever on your property. We have had clients walk away from deals because of this really old building scheme, because they're like, I wanted chickens.
I want
And I'm like,
bacon to
oh,
come with
I'm
me.
glad we talked about this.
Yeah.
So like, you just never know. And that's why it's so important, again, for clients to tell us what's important to them. Do you want a pool? Do you want a fence? Do you want chickens? I don't know. For me, here's a goofy one. I wanted a clothesline. That's my dream, the Okanagan dream. My grandma lived in Osoyoos.
Solar
I just
power
remember
dryer?
as a kid. Well, maybe in the winter, but in the summer, throwing the clothes out on the clothesline. I don't know. That was the dream to me.
Yeah.
And there's a building scheme on my property that said no clotheslines.
Really?
Yep, but it's expired. So I'm good. I'm still in compliance. I'm still being a good girl. But it's those little things that clients often don't tell you, right? They'll talk to the realtor about it, but I'm never walking through that property with them. So anyway, so building schemes, the people who are enforcing them are the other owners. It's not the city coming knocking on your door. So if you have a grumpy Karen next door, you have to be aware of it, right? You got to be following the rules. And sometimes people say, well, how do I know if they're going to enforce them or not? I wish I had a crystal ball. That'd be amazing.
Yeah.
Go drive through the neighborhood. Do you see anyone else with chickens or an RV in the front yard when it says no RVs? Typically, if people in the neighborhood aren't complying with it, likely no one's enforcing it, but you never know who's going to move in and actually read the thing.
So what's the process for the complaint then? They're not going to go to the city. They have to hire a lawyer and take you to
You have to get half a dozen eggs and you fire them at the house first, Taylor. Then
exactly.
if that
That's
doesn't
step
work,
one. Yeah. And that's why you need the chickens in the backyard.
Yeah. Toilet paper in the house on Halloween also helps.
Right. But so to get this thing removed, so we've run into it before where someone has in the contract before getting legal advice committed to, I'm going to be removing this statutory building scheme. You're probably not. Like, that's not something that's easily done. To remove a building scheme, every single owner who is subject to that building scheme has to agree. But not only that, they need to sign in front of a lawyer. So you can be rallying the troops of 20, 30, 40 people. And so maybe you're going to pay your lawyer to go door to door and hope that no one has passed away, hope that there are no tenants in the property, that the registered owner of the property happens to be there. It's a big thing. The alternative is you can go to court and apply to have it removed. This has come up a few times, kind of in the areas, I don't know, Sutherland, the areas where they're really trying to get rid of the single family homes and build condos or townhouses, that sort of thing, because those would be contrary to the building schemes right now. And so you can kind of argue that this thing is so obsolete and no one is using it and it's for the best interest of the city to get rid of it. You can go down paths like that, but don't agree to remove a statutory building scheme. Just don't do it unless you've talked to a lawyer and you know that everyone is on board for it.
Back to my original question. Say I registered like a covenant or something barring the next owner from doing something. Mm-hmm. Is there anything from stopping them from getting the property and just removing that? Because I guess if I did that, I'd be the only one putting it on. Yeah,
but you would actually also be the one who's benefiting from it, right? So same way that the city can tell you you can't build on this certain area of the property because of geotechnical concerns or something like that. The city would have to consent to you taking them off. It would be the exact same for, yes, you have registered saying you're not going to build over X height, but you also, you on your new property has to consent to removing that. And you're probably not going to if you've gone out of your way to register it on. Okay, so we see that a lot in the new development kind of world, where so long as you still own that property, you can register whatever you want on there and you can move, go down the dusty trail and they would have to try to track you down to get you to remove this thing, which is tricky with individuals because people pass away. Companies, sometimes they go under too, right? Like they just disappear if it's no longer relevant. Sometimes we even see that come up with companies who have done developments in areas and they've incorporated this company just for this one, neighborhood. And now here we are 30, 40, 50 years later, company's gone. Who are you going to ask to get things changed or removed so it can get kind of funky? But again, these are things that the lawyer should be looking at, talking about, asking the questions. And clients too need to be advising, what is important to them or what would be a deal breaker or something that's really, really important to them, deciding whether or not they want to go forward. Do they want a shop? Do they want a pool? What does that look like?
Are you seeing more holdbacks? And would you like to see more holdbacks? I mean, probably not. It's a headache for you, but I'm just asking because it seems like pretty common now. Like these are very large assets, and there always seems to be a bit of a discrepancy of somebody thinks that the TV mount should be there and then it's out, or, yard hasn't been upkeeped, or even a pool saying, hey, pool should be serviceable by the time we move in, but then
Cleaning's a huge one.
not. Yeah, there's just,
Carpet cleaning.
there seems to be a
Carpet
lot of
cleaning.
stuff.
Yeah.
No carpet will ever be clean enough
Yeah.
for a new buyer. That's all there is to it. It's never going to happen.
Cleaning too, like it's so subjective, right?
Yeah, right. It's tricky. So there's an important logistical part of closing, right? So the buyer's lawyer is going to register to transfer the property. And there's undertakings, which are promises that are unbreakable. If you break them, you have to report to the law society. Like no lawyer wants to be risking their own reputation and career for it. So you make certain undertakings to pay money and pay out certain things, cut the checks for the commissions, do all of these things. Once the money gets sent to the seller side, unless there's a holdback or something telling them they can't release that money is gone. And that seller, they are probably not circling back. Like they are going to disappear off into the sunset. So if you have an issue that you find the day you move in, and often we do see closing on one day and possession on the next day. Closing being the date that you become the registered owner of the property. So that's when your insurance kicks in. That's when technically you are the registered owner. Possession is when you are actually moving into the property. So if you move into that property and there's issues, it's very, very, very hard to get that money back, if not impossible. Some people are really wonderful and they have, high moral standards and they say, oh my goodness, I'm so sorry. I didn't know this was an issue. Here, I'll pay that much back. And it has happened. There are really, really good people in the world. But I would say the majority of people, once they have their money, they're not talking about this. So what a holdback is it's an agreement before closing saying, I'm going to hold back X amount of money for this specific purpose. So do I want to see more holdbacks? I'm okay with it as long as it's in the contract and it's written well. Where we run into issues is sometimes, again, this is something we're looking at in the contract early on, that if I have questions about the wording of a holdback, hopefully it can get amended at the same time or when conditions are coming off. So what do I want to see in a holdback? I say go back to elementary school and think who, what, where, when, why, and how. Because I need to know to a T exactly who is going to be holding the money. Is it the buyer's lawyer, seller's lawyer? How much is it going to be? How are we going to know when to release it? I don't know, the door is repaired or the window is repaired. Okay, but who's going to confirm that? Is it the buyer? Is it the seller? Is it the contractor? What does that look like? So that has to be set out in there, because otherwise the seller's saying, I went in and I screwed in a new doorknob or whatever. They could say, yeah, it's fixed. We're good to go, release the money. What happens if nothing ever happens? This thing is dragging on for months and months and months. I need that money out of my trust account. Contrary to many beliefs, I don't want people's money. I want it in the trust account, out the trust account, because we have to balance to the penny. If there's one penny out, we are reporting to the Law Society. We are doing all these extra steps. We cut checks to people for a penny that never get cashed in stale date. I don't want extra money. So those are the important things. If nothing's going to happen, on what date can I just cut a check out? Whether it be to the buyer, to the seller. So I need to know all of those details for it to be a proper holdback. Now, what's an appropriate timeline? Totally depends. I'm holding one right now that is going to be in trust for a year, because there's some major remediation work that has to be done from an old gas station or something like that. A year is appropriate. If it's a matter of, I don't know, fixing the fridge or replacing, an appliance, 2 weeks, 30 days, like that should be plenty of time to run down to Home Depot and get, something put into the property. So it really depends on that. What I think is more appropriate than anything else, and some realtors do this and I love it, maybe contrary to what other sellers and realtors would like, is a walkthrough before closing, kind of 2 days out, even 1 day before, doing a walkthrough. And some sellers will say, I'm in the thick of packing, or of course it's not going to be.
That's the biggest pushback. It's like, you're seeing our house at the worst possible time.
I know, right? But I don't really care if it's dirty. Like I can generally tell someone who's packing in an orderly fashion are going to be cleaning up the property. What I care more about are their huge issues that we didn't see. I've had an amazing realtor. She puts us in every single one of her contracts. 2 days before closing, we found a massive retaining wall has collapsed. And that is tens of thousands of dollars that we never would know. That money would have been long gone. And so if I know that there's a major issue like that, I can deal with it before any money is changing hands. I get pictures, I get the whole bit before, because while I have the money, I can get people to do things or at least talk about things and try to act reasonably. Once I've cut the check and it's over in the sellers, I have next to no power. I can send a grumpy email, Beyond that, like,
So what do you do in that instance? Say you're 48 hours till closing and
mhm.
there's, $20,000 worth of damage, say to a retaining wall. Do you just say, okay, we are not funding, like we're not going through with this transaction until we do a $20,000 holdback. We sign off on that.
How do you know it's 20,000 though?
Well, yeah,
So it's a great question, right? So what I'm saying is I want a photo of whatever this big issue is. I need at least 1 to 2 quotes. The realtor, the buyers, they're scrambling, right? Like no one wants to be dealing with this. They're getting tradespeople in there to give them some sort of quote to say, here's approximately what it's going to be to get it fixed. Because I can't just go arbitrarily email the other side. I need an extra 20 to 30,000.
Yeah,
Hope that's
yeah.
cool. Thanks. You have to have some sort of backup. And I find that once you have pictures, like it's very clear that you're taking this seriously and that this is a reasonable thing to do. Or you say, no problem. Seller has to get this fixed in the next 48 hours. Good luck. Because the seller has an obligation to provide the property on the possession date in the same condition or substantially the same as when you viewed it. So if there's a major issue and they're not doing that, they're in breach of the contract. So you can't say, I'm not going to close unless because the buyer then can actually put themselves in a bit of a bind where it's called anticipatory breach, basically saying, I'm going to breach this contract unless you do what I'm going to say. So you can't do that. It's more of a request, a polite request.
And so if the seller just pushed back and said, forget it, I'm not doing it, does the transaction just not go through, or what are the repercussions?
Typically, you would still close and then you sue.
Okay.
And no one wants to do that, right? The issue with suing after closing is typically you're not going to be dealing with the same lawyers. So I do happy law. I get to deal with happy people 99% of the time who actually want to come see me because they're buying a house, they're selling a house, they're incorporating a business, selling a business, whatever it is. So they actually want to see me. Once people start fighting, I am not very helpful. They need to go to a litigation lawyer, which is a totally separate branch. So no, I shouldn't say no, but very, very rarely would you see a litigation lawyer also be the one completing a real estate transaction. So you're now going to have to go hire a litigation lawyer. It's going to be very expensive. This is where the cleaning comes in. It's a few $100, or the carpet cleaning, or I don't know, a couple light bulbs, or whatever it is that people get very, very upset about because they've spent all their money on this beautiful home and here are the issues with it now. The issue is you're going to pay more in legal fees in your consultation than the money is worth. So there are small claims processes and things like that. But again, it's the time, the money, and the energy that goes into it that's just such a pain. So if you can have a holdback, or if you can do an initial walkthrough and put your solicitor to work before closing, you'll have 2 days of stress rather than months and months and months.
But even if they don't close, like even if you do a walkthrough before, the seller still has to agree to it, or else the buyer has to breach the contract.
Yeah, you don't want to breach the contract.
No, exactly.
So what happens if a buyer breaches a contract is they would be responsible for any damages incurred by the seller. So that can be, commissions that they have now committed to paying, legal fees that they've incurred. But the bigger one to keep in mind is if the seller has to relist the property and they can't get the same purchase price, the buyer in theory is responsible for that shortfall. So buyers generally don't want to. The truth is, by the time you're a couple days out from closing, no one wants to breach the contract. I shouldn't say no one because we have had situations, but very rarely, like you've packed up your life. You've called TELUS and you've sat on hold for 2 or 3 hours to change your address. Like it's happening. In Kelowna specifically, this is one of the most beautiful things about working in Kelowna is you have connections and relationships with the other professionals in town. So I know a lot of the realtors. I know a lot of the mortgage brokers. I know a lot of the lawyers, particularly the lawyers who do areas of law that are similar to me because we cross paths. So it's great to be able to pick up the phone, even the assistants, right? So like your assistant is a pot of gold. Like you need to treat them well. If anyone mistreats my assistant, I will go to war because without my assistants, I'm not all that helpful. Like I need a team behind me to actually make things happen while I'm sitting here doing emails and meeting clients and doing
recording podcasts.
Yeah, exactly. Right. They're working away, grinding it out so that I can sit here and chat with you guys. So anyway, it's this beautiful thing where you can call in favors. And if you're a good person who works hard and is reasonable, and when things come up, you deal with it rather than sweep it under the rug, you get respect in the community. And it also goes the other way, right? Like if someone is a bit of a jerk, they're a bit of a jerk and you're not going to go out of your way. And the thing is, it's tricky for clients to get that sense or to know who they're dealing with and what their relationships are in the community. If you can ask, I'm sure there's people who would happily speak highly or low of any person, right? But I can sit very happily and comfortably saying, if I need something, if I have a seller and they're leaving town early and I need documents from the buyer side a week early, 2 weeks early. I'd say, can I please, I'm like, if there's any way we can make this happen, I have no doubt that we can make it happen. I'll send a Starbucks card. I'll, be nice. And, it goes in a little IOU bank. And when they need a favor, it's a no problem. Like, at the end of the day, we have to advocate for our clients. So am I ever going to, bend over or back away because I have a good relationship with the lawyer on the other side? No. But can I go into the conversation knowing that I have someone who I respect and who respects me back? You get so far.
Yeah.
So I think, again, where you have the backup, generally speaking, you get a lot farther than just saying, my client wants X amount off. It's just not going to happen. And when we're dealing with firms from outside of Kelowna, again, you're running into a different dynamic of relationship and what they're willing to negotiate on or not negotiate on.
I find that's almost the number one factor. Things are going south. It's like, who's the other side? Usually from Vancouver. It's like, God. Yeah. Honestly.
And I think it's just a thing. And it might just be a big town thing or that things are just done differently.
Yeah. I think it's just a difference of procedures that just cause headbutting.
It truly is. Whereas I think we're a lot, and again, I can't speak for all of Kelowna, but the professionals that I get to deal with are really, really nice people.
Yeah.
Where if you need something done, or if I have a back-to-back transaction, I let them know that they will bump it to the top of the pile.
Yeah.
So that we can all get things done in an orderly fashion and everyone talks and everyone communicates really openly. It's when you're dealing with people that you don't know and who have different processes and don't do things the same way that we do. Like there are certain documents that firms in Vancouver will ask for that we just don't do here that aren't relevant or it's just not our standard practice.
Yeah.
The other really, really big thing to keep in mind is Vancouver firms are a little bit different in how they deposit funds. So with us, firms in Kelowna, we will direct deposit it into the lawyer's trust account. That's typically how it's done. Very rarely is it wired. You physically take a check down to the bank and deposit it into the other firm's bank account. No biggie. Super important because the money is released right away. You can then use it for, if you're waiting on sale money to close a purchase. Boom, boom, done. We're all going home and making dinner.
Yeah.
In Vancouver, some firms will do that, but because it doesn't expressly state that as a requirement in the contract, some of them will say the check is ready for pickup at our office. Well, we are 4 hours away, so that's not very helpful. So we would then have, some of them will put their foot down and say, absolutely not. I'm not going to the bank. I'm not dealing with this. You come pick it up. So we then have to send a courier to go pick it up and bring it to us. It's not going to happen. If we need that money for a same day closing, it's over before it began. So it's, again, knowing the logistics of things and how it works. It's just important. And some firms in Vancouver will require you to certify the check. So a solicitor's trust check, it's just a fancy check that comes straight out of our trust account. It's as good as cash. But some firms, especially in Vancouver, want you to certify it first. So you take it to the bank first for them to certify that the funds are good. And then you take it to wherever they want it to go. And it's just an extra step. It's an extra expense. And sometimes it's just very, very difficult logistically to get it all done. So again, it's just a difference in who you're working with and understanding their processes. And again, asking the questions as early as possible to know, are we going to run into any surprises on the closing date? Because I would just rather not.
I want to ask one more question before we get into a wrap up, talking about surprises.
Yeah.
So fire season, you literally said there's a fire in South Pandozi today.
Yep.
What happens? Because this obviously happened a lot last year. Once there's a fire, insurance companies won't insure, transaction has to be delayed. Can we mitigate that at all?
It's such a good question. And it's becoming more and more relevant. Of course, we think forest fires in Kelowna. We had a huge fire in our backyard last year. So it's all very fresh. This has been an issue for a long time. Floods and fires. Any kind of extraordinary weather events are what we're thinking about. So why do we care? It's because anyone who's getting a mortgage, one of the conditions, without a doubt, is that the bank wants to see property insurance. Because if the house burns down, the mortgage is not going to get repaid and they don't have anything they can foreclose on and sell. So that's why the bank cares. If you cannot provide them with that insurance binder, which is just a fancy piece of paper saying, yes, the property is insured, that shows the bank's name on it as the lost payee, they're not giving you any money. If we don't have money, we're not closing. So that's where we run into an issue. It's not actually an issue if a buyer's paying cash. If they're paying cash and they still want to close on this deal, no problem, property's yours.
Even if they can't access it?
Yep.
What about if it's burnt down?
Yeah. Oh, see, you are just getting right on my alley. Okay. So basically, that's why we run into the issue
Yeah.
is we need this insurance binder so we can get money.
Yeah.
Perfect. Okay. So what happens if the property burns down, or what happens if there's an evacuation notice? We've run into both of those,
Yeah.
right? Where we actually had a situation where client is in the moving truck moving across the country and there's an evacuation notice and we do not know if the house is standing. It was like that close. It was within 1 kilometer and we don't know if it's going to be there when they get here or not.
That happened to McKinley last year, right? My neighbor was moving in the day the fire started, and then we didn't know if it was burnt down.
Yep. It's pretty crazy. So the important thing to keep in mind is that sellers are required to provide the property, I kind of mentioned this earlier, in the same condition as when they viewed the property. If the property is burnt down, they're in breach of the contract. They can't provide it in the same condition. So, I mean, again, are people going to be reasonable? Probably. But again, technically they're in breach. The other thing to keep
what's
in
being
mind,
reasonable? Taking over a pile of ash?
well, sometimes they'll delay and let it rebuild or something,
Okay,
right?
Yeah.
Again, like it's hard. It's hard and it depends on the people and it depends on the circumstances. So that's kind of piece number one.
Yeah.
Seller has to provide it in the same condition or similar condition. Yeah. The other thing to keep in mind, and this is the big one that people don't think about, is that a seller has to provide vacant possession of the property. Now, vacant possession does not mean here are the keys. They actually have to have access, physical access and possession of that property. If there's an evacuation notice saying you cannot, not an evacuation notice, like a demand, you must not go to the property. Technically, again, the seller's in breach of the contract, that they cannot provide possession of the property. We've run into that too. So all the seller's possessions are still there, or maybe they've moved out and it truly is a totally vacant property. If the buyer cannot get to the property, it's not in compliance with what has to happen. So it's a fundamental breach of the contract. Again, breaches, you start talking to a litigation lawyer. So what are the buyer's options? They can either accept that this isn't happening and they get their deposit back and move on. It sucks for everyone, but it is what it is. At least there's no harm, no foul. In theory, the seller's insurance is still in place. I'll talk about that in a little more detail in just a sec. They can either insist that the seller complete. There are certain steps that have to be done for that. This is an important one that people I don't think understand or know. Buyers and sellers, if you cannot get to the property to confirm if it is standing or the extent of the damage, both sides by common law, so by court-made law, have the right to delay completion until they can go see the property.
Even without a force majeure, they still have the right for that?
Yeah, if you cannot get to the property. So this isn't because you can't get insurance. Like you are barred from crossing the police line that says you cannot go see if this house is standing or not. I mean, the rationale being it's very hard for a buyer to make a decision if they're going to close or not close, assuming they can. Let's say, I got cash in the bank. I'm ready to buy this thing. If I don't know if it's standing, it's very hard for me to commit to that because I don't know what I'm buying anymore. Or they can complete anyway and just risk it, roll the dice, and let's see what happens. Realistically, you're only doing that if you're paying cash and if the cash buyer has insurance already in place. Because otherwise, that is a risky move.
Yeah.
Yep.
Might want to make a phone call before that one. Yeah.
Yeah. So if you do decide you're going to complete, you need to be thinking about what is this going to look like? Are there any adjustments that need to be done? Who is paying for accommodations of the buyer until they can get into the property? Who's paying for meals? Typically, insurance, if the buyer has insurance, will cover for a certain period of time. But beyond that, like if you're out for weeks, months, whatever, it's important to think about that. And then also the seller's personal belongings. If they're still in the property, you want something written into the contract or added in saying, once it's all been lifted, they have X number of days to get everything moved out, cleaned, because otherwise, again, you're kind of in no man's land of who's going to be responsible for what. So the big tips to try to mitigate this the best we can is include a force majeure clause. So you've kind of alluded to that. Force majeure, it's just a fancy way of saying, if I can't complete and it's totally outside of my control, we can extend for a certain period of time. So there's different versions of the clause floating around out there. Some I love, some I don't. There's actually a new one that was released not too long ago from the real estate board that I really don't like, if I'm being totally honest. The wording of it, I don't think is very appropriate or practical in how it flows. But anyway, I can save that for another day. But basically, you just want to make sure you're not just copying and pasting every time. Think about it. Yeah. And does it make sense in this scenario? And if you have a client who's buying and selling, you need to make sure the force majeure clauses mesh together.
Yeah.
So if, for example, you need the sale proceeds to complete on your purchase, the buyer on your sale has invoked a force majeure, under most wording, that's not going to be enough to invoke the force majeure on your purchase. So you could not have money from your sale. Now you're in breach of your purchase. So you have to think about connecting the dots there. So again, Don't be complacent. You have to think about it every single time. Again, a lawyer should be looking at that when they do their contract and title review and everything. Buyers, make sure that you get insurance as early as possible. It's a beautiful tip, but it's tricky in practice. Conditions have to be off. You have to know who your lender is, and the lender has to have sent over instructions to the solicitor, because in binding your insurance policy, we have to specifically note who the lender is, the address they want listed. All of that has to be in there. So it's not like you can put the offer in and then go to the insurance place next door. Like, there are steps that have to happen. The important thing for a buyer to know is you take over risk of the property 12:01 a.m. on the completion date, not the possession date.
Really?
So that is when your insurance has to kick in. Again, insurance companies are not going to change anything. Once there's a fire, it's over.
Yeah.
So it was actually easier for us on this one particular deal. Our client, who was the buyer, had bound the policy for the possession date the next day. We extended by a day because that was going to be a lot cheaper, easier for everyone than invoking force majeure. But again, if a buyer understands the logistics of it, 12:01 a.m. on the completion date, that is when your insurance has to kick in.
I feel like that's news for everyone.
Oh, there you go. Well,
yeah.
There's a fun little tidbit. Yeah, in the contract to purchase and sale, that specifically is noted in there.
Yeah, okay.
Saying that is when the risk transfers over. So if a property is standing at 12 o'clock and burnt down by 12:02, the buyer's insurance is the one covering it.
So you have closing, and then I have had listing agents that won't give me the keys until the specified possession time, even though the house is vacant, nothing there. They just want to follow the contract. Like, does that make sense at all to you, or is it just...
Yeah, it's whatever's in that possession box, whatever section it is in the standard form contract, they can put whatever time they want in there. And that's technically when you get possession, but you take over risk. 12:01 a.m. on the completion date, you'll be fast asleep. Congratulations. The risk of the property is yours. So yeah, that's when you want insurance to kick in. The other and probably most important piece, if I can give one takeaway for mitigating risk with fires, sellers should not be canceling their home insurance policy. Period. Don't call them and say this is the closing date, because on the insurance company's end, they will type that date in and that's when it ends.
From experience, it's easy to call and just get them to back pay you even a couple of months later.
Yes. My preference is don't cancel it. Don't even pick up the phone until the money is in your account.
Yeah.
Because if the buyer invokes the force majeure, you can be left in limbo because they will not reinstate your policy.
Yeah.
They will do a new one. And they won't do it if there's a fire within X kilometers, whatever their policy is.
Yeah.
So don't touch it. Don't do anything with your insurance. That is the last thing you want to do. For the couple extra days that you'll be spending on paying your premiums, you'll be able to sleep at night knowing there are no issues.
I sold a rental property once and I just totally forgot about the insurance. And then I realized like 6 months later, and I called them. I said, oh, I actually sold this property back in March. I just sent them the contract and they just sent me a check the next day.
Well, that sounds lovely. That's a beautiful plan for whatever insurance company you used. That's just great.
I just mean, like, it makes total sense to just get out of the property first and then deal with it.
Cash in the bank account. Yeah, you want it in there before you cancel that, because again, if there are any delays, and it doesn't even necessarily have to be a fire. Maybe there's the smallest issue, like someone couldn't sign on time or documents got lost in transit or whatever it might be. It doesn't happen often by any stretch, but it's not totally unheard of. Like, it happens. And so to make sure that you are covered, I think is just so important.
Yeah, I agree. That's great advice.
Yeah. So forest fires, I'm hoping with all the rain we've had that we're going to have a nice smooth season, but we're in a pretty hot stretch. So we'll see. But I think those are kind of the steps buyers and sellers can take to best protect themselves. And again, legal advice as early as possible. Make sure your lawyer is reviewing the contract. If they're not the lawyer that you should be hiring.
Yeah.
Agreed.
Okay, we'll fire our last questions at you super quick and wrap this up, if that's okay with you.
Yeah.
If you could buy one property in the Okanagan in the next 12 months, what would it be?
Big White. Love it. It's magical up there. It's the dream. I have young kids and I just want to be up there. I need to be up there. And it's booming. I love it.
Awesome. If you could give your 20-year-old self any piece of advice, what would it be?
This will be an interesting one. Nothing. No advice. I don't want to hear it. I think life is
love it. Fun. That's awesome.
Truly, I am so happy with my life. Yeah. I love professionally, personally, everything about my life is so wonderful. And again, not every day.
Get this girl a book deal.
Right? I'll spend my time. I'll do whatever. I had a lot of fun in my 20s. Yeah. Those days are dead and gone. People probably wouldn't believe the stories if I started telling them. That chapter is so closed, but I'm glad it's out of my system. And now I'm into this phase of life. And I think it's pretty special.
Yeah.
So yeah, no advice. This will be an interesting tidbit coming from a lawyer. I hate reading. Hate it. Reading contracts, the drier, the better. I don't want to read novels about, I don't know, anything. Nothing is ideally my world. So I love reading my contracts. I love reading titles. I love reading legal stuff.
Yeah.
Beyond that, I don't want to hear advice. My husband will be the first one to tell you, unless I ask for advice, I'm probably not going to listen anyway, and you're wasting your breath.
That's a great answer. I love that one.
I love it too.
Um,
That's the best answer we've ever had, I think.
what's your favorite charity, or how do you give back?
Yeah, so I would say Canadian Mental Health Association. They do amazing work, and mental health is so important. I think it's becoming more and more talked about, but still nowhere near where it needs to be. One of the way that as a firm we give back is when we do notarizations or a little kind of oddball, signing here or there. I don't think because I have a stamp or a seal where I get to, do a fancy mark on a paper, I should be any more special than anyone else. We don't charge for it. We just say, put it in the Good Karma Fund, or every month we pick a different charity to donate, $10, $20, whatever the person wants to pay. I think it's kind of those little things in life, and it always comes back full circle. You get clients that way, and if nothing else, I put in my Good Karma bank. And when I need a good day, it circles back.
Yeah. I love it. All right, Dani. So how can I or Taylor or our listener help you? What can we do for you?
Oh gosh, you know what? Honestly, if I can help in any way, I like to think that I'm approachable. I love what I do. Like I said, I will chat anyone's ear off about anything that I know about, and I'll ask a lot of questions if I don't know. So to be able to reach out and just, even if you don't think I'm the right person, again, having the connections with different lawyers, so family law lawyers, litigation lawyers, accountants, I have connections with just about anyone, and I will happily stand behind the people I refer to because they're very special and I know they do good work. So yeah, I would say just live a good life, take risks, do all the good things. Yeah, I mean, if I can help in any way, personally, professionally, I'm here. But beyond that, I think life is good.
I love it.
Great.
Thanks, Dani. It's been awesome talking to you.
Yeah, thanks so much, you guys. Have a good rest of your day.
You too.
Thank you.